provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. Now, the militia in this section does not have the same meaning as militia in the Second Amendment. And this is where some of the confusion comes in. But even if it did, all right, let's say that all these courts were correct, that the militia was actually the National Guard and the Federal Reserve and bodies of troops like that. The obvious question is that when our militia or our National Guard or our reserve units were in Kuwait, the obvious question is, were they there to execute the laws of the Union? Were they there to suppress an insurrection? Were they there to repel an invasion? This all applies to the United States. In other words, if the courts are correct, then what you would also have to look at is that any time that reserve units were sent overseas, it would be a violation of this section of the Constitution. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. Well, supposedly the states can appoint the officers, but you're going to find nowadays states can't control them. All the president has to do is pick up a telephone and tell the head of the National Guard in any state in the Union, you've now been federalized, and he now has a new commander-in-chief. This next one I'm going to skip because it concerns the District of Washington, D.C. to exercise exclusive jurisdiction legislation in all cases whatsoever over such a district not exceeding 10 miles square, etc. Well, a lot of people in the patriot mythology movement will tell you that what that means is that the federal government does not have any authority outside of Washington, D.C. in that 10-mile square area. The problem with this is that when this was put in here, Washington, D.C. hadn't been acquired by the federal government yet, and after it had, this clause ceased to have any meaning. Now, this last one, this is called the enabling clause. To make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. In other words, what they were trying to tell us back then, which they've lost sight of, is that if the laws are not authorized by the Constitution of the United States, they are null and void. Here's your problem. When you pass an unconstitutional law, who is going to actually say it's unconstitutional and do what he's paid and sworn to do? If you think it's the federal judiciary, which they would like to have you believe when all these people in their black silk dresses up there looking down on us mere mortals are trying to say that, well, we protect the Constitution. I'm going to tell you right now, that's so much crap. And let me prove it to you out of Bowden's Government by Judiciary. One of the things Bowden pointed out, and when I read it, I thought, you know, this makes absolute sense. He said, if you think for 1 second that federal judges are going to be the people who protect the Constitution, he says, number one, not only is that crap, but he also pointed out in 1932 that most of these disasters, like the Dred Scott decision, were the fault of the federal judiciary. He said, but to illustrate his point, prior to 1800, we had what were called the Alien and Sedition laws, which I mentioned earlier. And one of those laws is that if you criticized the federal government or the people in it, it was considered sedition. Now, when the First Amendment had been enacted just a few years before, if you'll recall, it said, Congress shall make no law, okay? And one of those was restricting the freedom of speech. That is exactly what the sedition laws did. And if you think about it for a minute, who enforced those sedition laws? Who sentenced people to prison? It wasn't Congress. I mean, Congress may have enacted the nonsense. There was not a single federal judge in the United States who ever took one look at the sedition laws and said, these are unconstitutional, I refuse to enforce them. On the other hand, they enforced them to the utmost, like the bunch of black-robed tyrants that they are. So anybody who thinks that the judiciary has changed from that day to this, if there is an unconstitutional gun law, if there is an unconstitutional drug law, if they have an unconstitutional anti-abortion law, in case you hadn't noticed, these federal judges will enforce them to the hilt. And the reason they will do that is because They're not there because they believe in something. They're there because they're a bunch of power-mad, arrogant, incompetent lawyers. Just recently, William Rehnquist was whining to Congress about, oh, these judges could make more money in private practice. Well, maybe they could, but if they did the same thing in private practice they do on the bench, they'd all be in federal prison. Next section we're going to go to here, and then I want to get into the Bill of Rights here in a bit, because that's going to show you, once you understand how the Bill of Rights is supposed to work, once you have the basic concepts, then what you can do is you can go to these jurisdictional statutes and say, okay, I can see where they violated this particular provision of the Bill of Rights, and I can then litigate it. But you've got to understand how this thing is supposed to work, and it's also helpful to understand how it's really supposed to work. Bowden's book will teach you that. Incidentally, you can get that book, even though it's real pricey, from some outfit, I think, in New York, John Gaunt and Sons. You can get it on interlibrary loan. It won't cost you anything. We finally decided we had to buy a copy because the third time we took it back to the library, and I was only up to page 400, and I was still in the first volume, I realized this was getting to be a nuisance. It was cheaper just to buy it. Section 9, a lot of this doesn't really have anything to do with us right at the moment. The privilege of the writ of habeas corpus shall not be suspended. Well, on the contrary, they do it all the time. No bill of attainder or ex post facto law. Bill of attainders, you better look that up in Black's Law Dictionary, because that's a hard concept to explain. Ex post facto. Now, one of the things I'm going to give you at some point here is I'm going to show you how to get in touch with what's called the Selden Society. Anybody here ever hear of it? Okay. Ex post facto. The first time this term arose, back in about the 13th century, the beginning of the 13th century, a knight had raped, I believe it was a 12-year-old girl. And about 6 weeks after he'd raped her, there was a statute enacted. I believe this was by Edward I. It was around 1290. And what the statute said is that if you rape someone, you're going to hang for it. And so they took this knight to court. They filed a criminal complaint against him. And the knight says, wait a minute, you got a problem here. And they said, what's that? He said, well, I admit what you're charging me with. He says, but at the time, it wasn't against the law. There was no statute, so you can't do this to me. And you'll find this in the Selden Society's reports. And so they had to let him go. They didn't like it, but they had to let him go. And that's where this started. The Constitution of the United States, something you've got to be cognizant of, was written in the language of the English common law. And there's only one source to find out what the English common law was in 1789, in 1791, in times previous. And that's the Selden Society. It's in London, England. I'm going to, hopefully, the next hour here, I'll write the address up for you. And what the Selden Society does is they do research, and they print old law books from centuries ago. That's where I read about this case. It was from what they had done is they had translated this case from the law French. It was an actual court record that was put down about the year 1290, and year by year, they try to update these books because, again, everything's in law French up to the year 1500. And if you have a question about what the English common law was, because in the absence of statute, the common law controls, our Constitution was written in the language of the English common law, and ex post facto means the same thing right now as it did in the 13th century, in 1290 AD. They have some other interesting things that they'll tell you from the Selden Society. For example, they had a case in 1264 AD, rather long-running case. It's a civil case, some kind of real estate squabble. Would anybody like to guess when that case ended? It's a long case. Any guesses here? 1264 AD. Well, Harvey, that's a good guess, but there's only one problem.
What was the guess? Still running?
A century, that's correct. You got it right the same. That case is still being litigated today, 700 and some odd years later. And you think you got problems in this court system? Okay. No, they've had cases in England that have literally gone on for hundreds of years. I mean, that's how bad their court system is. That's the court system we've got. All right. A lot of our court system actually was not based. Now the Constitution, now be very careful here. The Constitution is written in the language of the English common law, but we did not try to adopt the English system. Because the English system, for example, their parliament, there's one example in the Federalist Papers where they point out that the English parliament, because the English parliament could change the Constitution, didn't have to be done by the common people. Well, one day they changed it so all of them would serve another 4 years in office. In other words, everybody that was elected for 4 years, they all got into Parliament one day and said, you know what, we're probably going to get thrown out in this next election. Let's just change the rules here, and we'll all just vote a change in the Constitution to extend our tenure in office another 4 years. And they actually did it. So that's not the system we have. We do not have the English system. What we have is that the language of the English common law controls, and when there is a principle that you will not find in the Constitution or in our statute law, then and only then does the common law control. One of the Selden Society's little squibs concerned a case that was litigated somewhere here in the United States. Nobody could find the principle until they went to the Selden Society. Incidentally, the Selden Society is mentioned in Supreme Court reporters. Federal judges know who these people are. They're mostly academics. And anyway, the Selden Society located a case from something like 1664 with the controlling legal principles, and that's how the case was adjudicated. So if you really want to be thorough in your understanding of constitutional law, you not only have to go back to the source documents of the Constitution, but you have to read the history. And if you join the Selden Society, it's only $50 a year, and they send you all kinds of goodies. We got like a couple of hardcover books that you can't get anywhere else, one of which had this 1290 ex post facto case I was describing. Well, actually, I'll try to get this up here on the board for the next hour. Now, let's see here. We've got regulations of commerce. So I'm trying to look here. They're talking about no titles of royalty. That would be fine, except that we've got all these people with sovereign immunity, which was never there in the first place. In Section 10, you're going to find that's the, let's see, what is this here I'm looking for? They can't pass any law impairing the obligation of contract or grant any title of nobility. Well, law impairing the obligation of contract means that once you have entered into the contract, the state can't pass a law. But if you haven't entered into it yet, the state can pass all the laws it wants, and then you basically have a problem. Article 2 is the executive. We don't need to pay a lot of attention to that. Article 3, that's the judiciary. You're going to find that Article 3 and Article 4, Article 5 and Article 6 have, they still have a lot of relevance today. But Article 7, it simply concerned 9 out of the 13 states voting for something, and that's toast. I mean, you don't even need to worry about it, even though it's a fairly comprehensive section. Article 3 determines how judges are supposed to act and so forth. And notice this, everybody thinks that federal judges are appointed for life. Nothing is further from the truth. They're only appointed for terms of good behavior. And the fact is, right now, almost every one of them is misbehaving. I just read you one, this Rudy Brewster. I mean, 100 years ago, this guy would not have survived 20 minutes on a federal bench. And today, it takes 20 years and he's still there. Article 4, this is the Full Faith and Credit Act, and let me warn you about this one here. This is going to get nasty. Remember the part in Hawaii where they just ruled that homosexuals can marry each other? And Congress has passed an act saying, we're not going to recognize that. I'll guarantee you exactly what's going to happen, just like it did in Colorado in that last rather queer case they had out there called Romer versus Evans, is that when somebody enters into a contract in Hawaii and they litigate it in federal court, some federal judge is going to rule that the Full Faith and Credit Act applies, because full faith and credit simply means that the judgments of any state court or state legislature or whatever you've got in one state must be accepted as valid in the other 49 states. You lose a case in Hawaii, you've already lost it in Missouri, because the courts are going to uphold it. You want to finish this up, Peter?
Just real quickly for the benefit of the audio tape audience. If you want to hear more, Michael Brown is on satellite radio. The satellite is GE1, It's transponder 7, 103 degrees, 5.8 wideband audio, and he is on 6 p.m. Central Time, Monday through Friday. Gee, I remembered it. Amazing. We are going to take a short break. We have to spin the video and cue up the next tape. Take 10, we'll open the doors, stay close, and we're going to drag at least one more out of him. Thank you very much.
All right, what we're going to do here is I'm going to go to Article 5 and Article 6. We're going to start on the Bill of Rights. If there are any questions, because we're going to have to apparently break up this little tea party at 6:35, I would like you to start lining up anytime you feel froggy and want to leap in, because once I'm through with this section, I'm going to turn my part of this over to 4 of my senior officers that I've already introduced you to. Probably won't get to them till tomorrow morning. I'm going to let them do their thing, and then Dwayne Rogers is going to take over. So if you've got questions, I need them now, okay? In other words, if you've got any more questions, just start lining up here. I will start talking on this, but if you have questions, get up here and let's ask them. Now, Article 5. Article 5 concerns how you are supposed to amend a constitution. You are not supposed to amend it by judicial construction. And those of you who've already got this little booklet here, which I strongly recommend because you're going to find it'll fit in a shirt pocket. It was designed to replace the Citizens Rule Book that's been out there for about 15 years, and the judges took them a while because, you know, they're not too bright, but they figured a way around it. You'll notice today that jury nullification is a subject that judges are very familiar with, and the first thing they do is they ask someone, are you a member of such an organization, or do you believe that you have the right to nullify a bad law? Over 100 years ago, a federal judge would tell a grand jury, before you indict one of your fellow citizens, ask yourself, did Congress have the authority to enact this? Today, we don't have laws enacted by Congress. We have suggestions. And what Justice Harlan pointed out in 1910 is that he had seen constitutions, he was talking about state constitutions also, amended by means alone of judicial construction. He was also talking about statutes. Now, the thing with Article 5 is that you're supposed to be 2/3 of the House shall deem it necessary and proper, shall propose amendments, then it has to be ratified by 3/4 of the states. And you're going to find there are all sorts of statute laws on the books that were not put to us in the common herd. The Congress, merely by legislative enactment, amended the Constitution. So here you have a Constitution that's supposed to be amended by the people, that first gets amended by legislative enactment and then gets amended by judicial construction. So what we wind up with isn't even recognizable at the lower end. Now, the reason I'm bringing this up, even though you all know it, is this. Most states also have provisions for amending their constitutions, and if you think that the federal Congress has got some dumb people in it, let me introduce you to some of these state legislatures. You'll find, for example, most state legislatures have a provision, Missouri being one of them, New York being another, I believe, that the right of the people to keep and bear arms shall not be infringed. And in Missouri, the only authority given by the Missouri State Constitution to the legislature is to regulate the wearing of concealed weapons. Notice I said wearing of concealed weapons, not possession. And the Missouri State Legislature, in its infinite wisdom, decided that that meant that anybody who had been in prison, who'd had a felony conviction, could only own a firearm that you couldn't conceal. It had to be at least 16 inches long. That is not what the Missouri State Constitution said. Now, in Missouri, there are other states that have this provision. We haven't done a complete search just yet, but I think you might want to look. Those of you who get into this, pick out your state and go look for it. Remember what I told you about that declaratory relief petition, that you can have a jury decide the law instead of a judge? No one in Missouri has ever taken this provision to court and demanded a jury trial as to whether or not that particular legislative enactment by the state of Missouri is in fact illegal according to the Missouri Constitution, because it was not passed by referendum, it was passed by legislative enactment. And again, on the state constitutions, you're going to find quite often that your state constitutions are actually better documents than the federal Constitution. Your biggest problem, as they pointed out in the Federalist Papers over 2 centuries ago, is that you can get a federal constitutional infringement adjudicated in the federal courts. You may get it adjudicated wrong, but at least it can take place. And nobody seems to know how to do this in the state courts, which is hopefully what I'm teaching you here. Next, we're going to go to Article 6, which is the supreme law of the land. Now, obviously, I'm going to have a question for you. If the United States Constitution is the supreme law of the land, all right, all other state judgments or whatever notwithstanding, let me ask you this question. The Fifth Amendment is as much a part of the Constitution as any other part of the Constitution. You'll find Supreme Court decisions going back for 2 centuries on that. This is the same Supreme Court that said that the indictment of grand jury clause of the Fifth Amendment does not apply to the states. Now, the question is not whether it should or it shouldn't. The question is this, is if a state judge takes an oath to uphold the Constitution of the United States, and the Fifth Amendment indictment by grand jury clause is part of that Constitution, where does a state judge get off upholding what they call a prosecutor's information? No court has ever adjudicated that. I'll tell you something else they haven't adjudicated. There's a fellow named Sheldon Hansel up in New York. Now, this was my case. I'm the one who ran him through it, okay? You'll find it in the 70th volume of the Federal Reporters, 3rd series, page 6, case from last year. In the last year and a half, I've had 4 decisions published. One of them was a lesson in how not to do things. I didn't read one word on a statute. You'll see it in 903 Fed Sup, I forget the page number, and it's called Simpson versus Reno. You'll see my name there, you'll see Peter Simpson's name there. I did not read one word in a statute, and we got clobbered. In other words, it's how not to do things. On this one here, what happened was one of the issues we raised. Now, one of the issues we raised, we won. Another issue, we lost, but here's the way we lost it. We had raised the issue that indictment by grand jury has to mean now what it meant in 1791, what it meant in 1806, what it meant in 1903, all right? And that Congress had no right to amend the Constitution by means alone of legislative enactment. And the rule that we were squabbling about, this federal rule of criminal procedure, not civil, criminal, okay, was Rule 6D, or 6 dog. And the reason we'd raised that is because, as usual, as any of you who've had any experience at all with federal criminal law, know that the grand jury system has become a complete shambles. It's a total farce. It absolutely fulfills none of the functions that it did originally. And the reason is because of this rule here, Rule 6D. And what it says is that the attorney for the government may be allowed in the grand jury room. Now, this was not permitted in 1681. There's a real good case, it's called Remarks on Colleges case, College in Shaftesbury. London grand jury refused to indict them. Charles II had another grand jury convened at Oxford, which duly indicted them. Shaftesbury fled to the continent. College, who didn't have the money to get out of town, was beheaded. And what Sir John Hall, Solicitor General of England, pointed out is that government attorneys have no business in the grand jury room. Now, this was in 1681. It was a principle at the English common law. In 1791, this was still the law. In 1806, when the United States Attorney for Kentucky asked a federal judge to convene a grand jury, which a federal judge can do, the federal judge said, okay, finally, he got badgered into it. He convened a grand jury. And as soon as the grand jury was convened, Joseph Hamilton Davies, the United States Attorney for Kentucky, asked to attend the grand jury in their room. You'll find the complete account of this in an article titled, it's a law journal article titled Demythologizing the Grand Jury by Professor Helene Schwartz. It's in the 10th volume of the American Criminal Law Review, page 701. It's from 1972. And what Helene Schwartz pointed out is that the very idea of a grand jury, which has two functions, number one is to make an investigation, but number two, which is the more important function, is to shield the citizen from the awesome machinery of the federal government, because it's real easy for somebody to get gaffled up on political considerations. And we've got a gentleman in this room, Staff Sergeant E6, Ed Godelli, police officer from Pittsburgh. It's exactly what happened to his father. The United States Attorney made a political choice to indict him, set a perjury trap for him. He fell in it. He's in a federal prison. As late as 1903, when a government attorney got in a grand jury room, and you'll find this in the Japanese silk fraud cases out of New York from that year, the federal judge quashed the indictments. He said, no, he said, I don't care if these people did any harm or not. You do not allow government attorneys inside grand jury rooms. Now, that was the issue we raised. The issue we raised was whether or not Congress had the authority under the Constitution of the United States to change the mode of proceeding in a grand jury without submitting it to the people. They did not address the issue. What the Second Circuit Court of Appeals did, and the type of usual judicial cowardice that we've learned to expect from these people, is they said that the defendant's claims, because this was a criminal case, United States versus Sheldon Hansel, the plaintiff's claims have no merit because Rule 6D says, and these mindless parrots then repeated the language of the statute. Remember what I said about federal judges will uphold anything, no matter how unconstitutional? Because they're not accountable. And so what we did next was we turned around and we sued the Second Circuit. And we feel that the very least they can do is, I mean, these miserable judicial weasels, the very least that they owe us is to address the issue we raised, not an issue we didn't raise. And sometimes this goes the other way. For example, I had a case out of North Dakota. Oh, this is going back over 5 years ago. And what happened is that these two people were busted for theft of grain or some silly nonsense. It was a felony conviction. They'd been to trial, got convicted. But what I noticed is that on their prosecutor's information, they had more than one statute that they had been charged with. Now, if you ever get charged in a federal criminal case, look closely under each count. Because if you have two separate statutes, one of which contains elements of which the other doesn't, for example, if they charge you in Title 18, Section 371, conspiracy, and Title 18, Section 2113D, bank robbery, under count one, and a jury comes in and finds you guilty of count one, well, they've got a problem there. because nobody can tell whether you were found guilty of the conspiracy, the bank robbery, or both. All right, it's called duplicity. They're supposed to throw an indictment out for that, even though these judges have been watering that down also. You're going to find that in the civil courts, you can still book a winner. They're only about 90% corrupt. In the federal criminal courts, I'm going to tell you right now that you're only there to build a record for the appellate court, because your fellow citizens, by the time they get down to selecting the average jury, you're dealing with 12 people without 2 brain cells to rub together. They're going to convict you because the judge is going to help them. Anyway, this case up in North Dakota, what happened there is there were 3 judges on the panel, and I talked to the fellow that I'd done the work for, and he said when he was up there, 2 of these judges were addressing issues we hadn't even raised on the appeal brief. And the 3rd judge kept saying, what about this duplicity issue? Well, I was setting them up to take it into federal court on what's known as a federal habeas corpus for state prisoner statute, Title 28, Section 2254. And my 2 people won the case based on issues that we never raised, on facts that never happened. Okay? I mean, they actually will do stuff like that if you scare them bad enough. Article 6, that pretty well covers that. Now let me get into the Bill of Rights here. Again, remember this was given to us by the Anti-Federalists. As Patrick Henry said at the convention in Philadelphia, he smelled a rat. Congress shall make no law respecting an establishment of religion. Well, that's what they did earlier, like I showed you, but that's because the Supreme Court has been making laws left and right regarding establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. And when they meant peaceably assemble, obviously that still has the same meaning today, but to petition the government for a redress of grievances in 1791 didn't mean you wrote a letter to your congressman and he didn't respond. It meant Congress would give you a hearing. We don't have that anymore. Article 2, or rather Amendment 2, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Well, the courts have rewritten this to read, a well-regulated militia being necessary to the security of a free state, the right of the militia to keep and bear arms shall not be infringed. That's not what it says, as a lot of law journal articles will point out, that the word people had the same meaning in the First and Fourth Amendments, the right of the people to be secure in their persons and so forth. So it pretty obviously had the same meaning in the Second. And unfortunately, because of judicial construction, that's no longer true. Amendment 3, that's quartering of soldiers. I'm not going to cover that for the simple reason that it hasn't been a problem. And you'll find that the fewer problems that the courts create for us under these amendments, the fewer court cases there will be. Under the Third Amendment, it really hasn't been violated by anybody since the war between the states. So you basically find maybe 5 or 6 cases there. Amendment 4, and this is the one that this spawns an awful lot of civil rights litigation, because when I get through reading this, I'm going to explain that there's more to it than just walking